Good morning. Is it Coaches?
Good morning. Yes, Coaches.
Good morning.
Your Honor. And may it please the Court, Alexander Coaches from the Energy and Telecommunications Division for the Attorney General Martha Coakley. What the Department did not do in this case is apply a rule announced in another proceeding to the facts of the Fitchburg case. The mistake the Department made here was to make up a new policy and apply it without hearings or taking additional evidence.
I thought they'd had rather substantial hearings in developing the policy.
The Department, in a different case, the Bay State gas case, indeed conducted hearings. But what happened in Bay State is the Department allowed A, dollar-for-dollar recovery of the supply gas cost, B, in the context of Section 94 hearings, C, the Department adjusted the capital structure of Bay State to account for a lower risk profile, D, the Department indeed set just and reasonable rates, and finally, that was in the context of a gas case.
But let me ask you, in the Bay State case, did all those other components of the tariff have to be revisited because the definition of debt was also changed?
What happened in the Bay State case is that the Department didn't apply a policy it had been developing in earlier Fitchburg decisions. So it basically said, Bay State, we're going to leave your bad debt collection policies more or less in the old method, and we're not going to go in and adjust your tariffs for a new method.
Are you saying that whenever there's a contemplated change in formulas that there should be a hearing?
Yes, under the
Every time?
A full 94 hearing?
Every time there is a change in a formula under the Coffey decision in the earlier Fitchburg case here, yes, from this reasonable interpretation of the Court's early decisions, there needs to be a change in tariff formulas. There needs to be hearings in front of the Department.
We've had a fuel adjustment policy for over 30 years, and this would seem to me to work the same way. It's a cost that the company has to recover, and it's objectively ascertainable. So why do we need a hearing every time?
Well,
how does it differ from the fuel adjustment?
In this appeal, we're challenging the lack of a hearing to amend an already approved tariff formula. When the formulas operate, I agree with you, Justice Cowan, that there does not need to be hearings. Here, we're not appealing the operation of the tariff, but amending it.
So you would say, since you've had a hearing now, right, in 2008, a Section 94 hearing where this came up, isn't that true?
No. We've had no hearings in the Fitchburg case when these formula changes were adjusted.
What was the proceeding? I thought it involved Fitchburg. That's a 2008 decision of the DPU.
There is, yes, that's a separate rate case for the electric side. And
didn't this issue come up in that, at least for the electric side?
In that case, the Department did adjust its capital structure for Fitchburg Electric to reduce the risk profile to account for the default service dollar-for-dollar
So
recovery.
my question is, going forward, and I know this isn't your case, but I just want to see if I understand the distinction you're making between the change in the formula and what happens thereafter. So going forward, with respect to post-2008, with respect to the default service, you would not say that for every year you need a Section 94 hearing. You would plug in the new bad debt numbers, right?
Exactly, Justice Botsford, exactly.
So you're just saying there was no such hearing with respect to either default service or gas after the decision, well, from December 2005 up until then.
Exactly, precisely.
But my previous question to you is, and you didn't answer it, do you have to have a hearing, a Section 93 hearing, because the debt collection component of the tariff will necessarily affect all of the other components of the tariff? Is that the reason you want the hearing?
We want the hearing to set a just and reasonable rate. It's not simply a matter of plugging in data into an existing formula. The formula itself changes. And as explained in the brief, these rate-setting formulas are complicated, and in this case, it touched on the company's risk profile. So it's a systemic change. There could be ministerial changes to tariffs. Obviously, when the supply cost data flows in, that needs to be passed on dollar for dollar. So long as the formulas that give you those numbers don't change, no, you don't need a Section 94 proceeding. A full-blown rate case would be ideal, but there may be instances where something less than a complete a rate case would be appropriate to adjust rates so that they yield a just and reasonable result for
So
customers.
I'm not sure I understand. Are you saying that we wouldn't need a hearing every time there's a shift in the amount of bad debt that the company incurs? We wouldn't need it?
You would not need when there's a shift in the amount, no. That's the purpose of reconciling fuel clause in this case, is to flow those costs on to customers. When the data that calculates the rate changes, yes. You're amending the tariff formula. I'm sorry, I misspoke. When the formula changes, you're amending a tariff formula, you're changing the tariff, and you need to have hearings under the coffee decision.
But the formula change, maybe this is so bizarre, all of this talk in here about all of these terms, but the formula change, was that different than the formula change that the department said was okay in the Bay State case? A different formula change, or was it the same formula change that they had approved in a huge hearing in Bay State with lots of participants?
In the Bay State gas case, which was, again, a rate case, and rates were adjusted, and the capital structure was adjusted, very different situation that happened in Fitchburg, that the department essentially said Bay State can continue to collect dollar for dollar bad debt expense. In other words, there was no change, essentially, in Bay State's method. Fitchburg had a different method. They collected a certain amount less than the total amount of bad debt. So in Fitchburg, the department changed the formula and sort of restored it to, I guess, the Bay State standard.
Yeah, I take it the tariff for each one of these companies is individualized.
That's correct. Each company files an individual tariff, and that's very clear under 94.
So that the I'm using a very simplified thing, X plus Y equals Z. That is, if you don't use X plus Y equals Z for every company that has a tariff.
No, that's correct. As this case demonstrates, some companies were using dollar for dollar bad debt expense. Other companies weren't. Companies' rates are set under Section 94, and they continue until the company comes in and resets them. This case is shocking that you can reset the rates without a hearing. But in any event, different companies, therefore, will have different rate treatments until they come in to the department in a rate case and apply those policies, the new policies, to the current rates. Some companies haven't been in for decades, and they're operating under tariffs and formulas that were set maybe in the 90s.
Now, there are two parts to the rate. There's the base rate, and this is when you change the base rate, you have to have one of these Section 94 hearings. And then there's the CGAC.
Yes, the reconciling tariffs.
The reconciling tariffs, and you don't have to have 94 hearings when you change those.
Well, it depends on what the change is. If you're changing the data that goes into them, no. As Justice Cowan and Justice Botsford were discussing, when the data goes in, no, you don't have to have hearings. When you change the formula, which is part of the tariff rate that determines how much customers have to pay, when the formula changes, yes. And if you look at the Attorney General's brief in the introduction and the facts section, you'll see there's red line versions of these tariffs. They went from an algebraic equation to something very different, sort of a concept. It's clear the formula's changed
So
here.
when you had I guess I have two questions. When you had the hearing in 2007 or 8 or whatever, this issue got discussed, right, with the electric?
I believe the department ruled on the capital structure portion of the case, which is the most important
Right.
part
For
the Attorney
these
General.
purposes.
Yes.
My second question is, at least as I read the DPU's brief, there are a number of companies who had also had tariff changes to adopt this policy that the Attorney General did not seem to have any problem with.
Well,
I'm wondering why some and not others.
Well, there were two responses, maybe three. The first is that a universally applied incorrect rule is still incorrect. The Attorney General has many reasons for selecting a specific case for appeal, but the interests of justice aren't served by having 5 pending appeals before this Court on essentially the same issue with 5 records, all to be consolidated. This case, to our opinion, served the best vehicle to raise this issue.
Now, I've got in front of me Fitchburg Gas Light Company, 440 Mass 625. It talks about the CGAC, and it says that unlike the base rate, which is not subject to retroactive adjustment and may only be changed pursuant to the hearing procedures set out in 94, the GCAC may, for good cause shown, be modified by the department in such manner as it may determine to be in the public interest. Isn't that what happened here?
No.
Okay.
What happened here, in that Fitchburg appeal, which I was also involved in, there was an error in data. In effect, Fitchburg had collected inventory finance charges twice, and this court had said you can only collect it once and ordered a refund. That did not involve a change in the formula. That was, if you go back and read the briefs, that was a heavily contested case as to the distinction between base rates and the reconciling tariffs, and that, whether this was just a change in data or a change in the rate.
So even if it's a change in formula relating to this cost of gas adjustment
clause, yes,
CGAC, you say a 94 hearing is required. Anyway, even though this case doesn't say that, even though this case suggests otherwise.
That's correct, and that case is consistent with the Attorney General's position in this case. That case just involved data, which flows in and out of the cost of gas adjustment formulas and default service formulas without further intervention from the department. It's when the formula changes that the court in Coffey said, hey, you've set up the formula, you're amending the formula, you need a Section 94 proceeding to evaluate it. And we asked for a Section 94 proceeding. Whether or not it's a full-blown rate case would be something we'd leave up to the department's discretion.
That's what I wanted to ask you. You're not saying you need the full-blown rate case?
Ideally,
the department under Section 94 can modify it? I mean, for example, in this instance, let's just say that the Attorney General's position is you need some kind of hearing because it's going to affect the cost of capital.
That's correct. Yeah.
But that's really all we need to do. Is that you could do something like that, you're saying?
You could. Under this case, that's the most direct part of the company's rates that would be affected. So there may be something more elan that the department in its discretion could implement instead of a full-blown rate case with, costs of service witnesses and weeks of hearings. We need something more than unsworn comments, unsworn data requests, no hearing, and an order saying rates go up. Whether a full-blown rate case would be appropriate would really depend on what the tariff formula changes were. They could be a brand-new global tariff that touches on every part of the company, in which case the Attorney General would say, this is just like a full-blown rate case. Something less might be appropriate as well, but in this case, there was nothing.
Mr. Coaches, could I ask you this? If I don't know whether it would be a 94 hearing, but presumably yes, but if the department had made factual findings to say, electricity is so, rate setting for electricity is so similar to rate setting for natural gas, and then articulated that, and therefore we're going to go with a base rate thing, would that have been adequate?
Assuming that they had hearings and took evidence?
Correct. And made factual findings on that point.
Yes, I'm not sure what those factual findings would have been. They could have cut for the customers or the company, but yes, the Attorney General would be looking for a hearing, taking evidence, ability to cross-examine. I believe one of the justices here said these bad debt figures are objectively ascertainable. That's not necessarily true. Companies have write-off policies where they're doing due and diligent collection efforts. Did they suddenly change how many days that they allow bad debts to stay outstanding? The Attorney General should certainly be able to kick the tires and check the math to make sure that these numbers were appropriately calculated and that the companies didn't just say, well, we're going to get dollar-for-dollar bad debt expense. We don't have to worry about collecting it anymore. Close the collection departments. We'll save some money, and we'll have all the other customers pay for it. Certainly, the Attorney General has an interest in ensuring that the company's collection efforts are prudent.
But am I misunderstanding this? I thought at this point you were challenging both the change to the GCAC for gas and the
default service.
DFS for electric. Are you challenging both of those decisions?
Yes.
All right, because you kept talking about electric as if in an event. So both of them.
Yes, Your Honor.
Okay.
But just to follow up on the Chief Justice Marshall's question, with respect to the policy of letting full bad debt pass through, customer bad debt pass through, there's not a lot. I mean, that's done. I mean, you can talk about how it applies to this case. I mean, that's what you're saying. But kicking the tires with respect to what are their policies of collection, I wouldn't think that would still be open. I mean, that's really what the policy change is, isn't it?
That was base date.
We do agree with the general policy of dollar-for-dollar bad debt recovery. That's within the department's discretion. When the department set that policy in base date, that was in the context of a rate case with rate hearings, adjustment of the capital structure, determination that there was a just and reasonable rate, and finally it was a gas industry case, not an electric industry case. But any cost appearing on the company's books that they want customers to pay, the Attorney General routinely investigates those costs, and the Department as well, to make sure that they're appropriately calculated. We're not saying, for example, that, well, you didn't do a good job adequately collecting on bad debt, so therefore the policy doesn't apply to you. We'd be essentially checking the math, making sure that companies' efforts are prudent. It's very routine in cost cases.
And what if they're not? What if the efforts aren't adequate? Do they go back to the original type formula, a certain percentage?
No, the Attorney General would say that any, and this is generally true in utility practice, any imprudently incurred costs are not recoverable from customers. I believe even the company would agree to that. If its management efforts were imprudent, like any other imprudent activity, customers shouldn't have to pay for it. We wouldn't be arguing for repeal of the bad debt policy per se. We'd be arguing under a different theory that, like any imprudently incurred cost, customers shouldn't pay.
Thank you, Mr. Coaches.
Thank you.
Mr. Bowman? You have 8 minutes, Mr. Bowman.
Good morning. My name is John Bowman. I'm a Special Assistant Attorney General appearing for the Department of Public Utilities, as it's now called. The Attorney General's position appears to be that a fleet cannot shift its course. That can only be done ship by ship. It's a recipe for administrative gridlock.
Well, Mr. Bowman, that's not really true. I mean, this is not challenging the basic proposition that the DPU can change its policy through a rate case. That is not the issue here. It's the application to this particular company. Okay, the policy was set in Bay State, and now let's see how it applies. Isn't that really what the problem is?
I agree that the Attorney General has said that they fully agree with the Department's policy in Bay State.
Well, they agree that the Department has the discretion to set that policy.
Yes.
Well,
right?
However we formulate it, Your Honor.
And then when it gets applied.
And the question of application really becomes quite simple at that point. And the reason it becomes quite simple at that point is Bay State said we have removed all supply-related bad debt from base rates.
But why doesn't that affect the tariff,
Right.
Fitchburg's tariff as a whole? Why don't we have to revisit the question of the tariff? Because we've changed the way we're going to calculate one of the components, and now we want to see how the other components of the tariff relate to that change. Isn't that the purpose of the Section 94 hearing?
We don't have to do that really for two reasons, but the strongest reason is that in 2002, there was a Fitchburg rate case involving both gas and electricity. And in that 2002 Fitchburg rate case, first of all, answering Chief Justice Marshall's question earlier,
Right.
the Department said that it would extend its policy on treatment of supply-rated bad debt in gas cases to electricity.
But that just changes that one component.
That does that. The second thing it did, Justice Spina, was in the context of the rate case involving Fitchburg, it removed all of the supply-related bad debt from the base rates. So we have a Section 94 rate hearing that has taken supply-related bad debt out of the base rate, moved it over to whether you're going to call it the CGAC or the default service tariff. They're functionally equivalent for our purposes. It's a reconciling mechanism. So we know that we've already got it out of the base rate. Some stays in the base rate. That is, the distribution-related bad debt stays in the base rate. It's done on the traditional method, historic
What
test
about
year.
cost of capital? Why isn't it going to affect cost of capital?
Well, the cost of capital, I guess, is potentially the only issue here.
It's not a small issue, is it?
Well, it's a fairly small issue, Your Honor, because in the 2002 Fitchburg rate case, first of all, the Department started off by tweaking its earlier policies and saying it was going to put some sort of a cap on the amount of supply-related bad debt would pass through.
75% or something?
But it had already set the amount of bad debt in that rate case. All that happens by the time Bay State comes on is it lifts the cap, not just for Fitchburg, but for all gas and electric companies. So the logic would apply to everyone. That is, the formula change, if you're going to use the Attorney General's logic, takes place in Bay State in 2005.
But there is a tariff that Fitchburg has. And in connection with this, it submits to the department that tariff with words crossed out and changes in the language. Now, isn't that going to have an impact on the overall rate, as Justice Fina said?
But that is simply Fitchburg implementing the base rate decision, because it can't charge anything that's not in a tariff.
Okay, I guess then I go back to the question, why isn't that going to have, because you're making this change, why isn't that going to have some impact? Or don't you have to look as to whether it has some impact on the cost of capital, which is a component of the Section 94 case?
That, of course, would probably require us to do a soup-to-nuts rate case, but let me answer it indirectly.
Why? Because Mr. Kocher said you wouldn't have to do that.
I realize he said that. Until that moment, I think everybody who's looked at this case thought that the Attorney General was arguing for a soup-to-nuts rate case. And to circle back, if we are going to hold out and only measure supply-related bad debt, which had already been set in a rate case, that is the Fitchburg rate case in 2002.
But you changed that.
Well, it picked the cap off of it, just like it did for every other company. And what I want to add to that, my answer, is that in the 2002 Fitchburg rate case, the department set for Fitchburg a 10% return on equity, which is described as being at the lowest end of the possible range of returns. When we come back to the 2007 rate settlement with the gas rate settlement with the Attorney General, they again picked 10%. When it comes to the 2008 electric rate case that you referred to earlier, they picked 10.25%. So it doesn't appear that there's any effect on the rate of return on equity in this whole picture.
That is not the argument you've made. I mean, that would be a different point, wouldn't it? I mean, isn't that sort of saying, look, let's talk about whether we need a hearing, Fitchburg. This may affect the cost of capital or the rate of return, and so what are you going to do about it? But that's different than what I take it to be the department's argument is we don't even need to go there because the change we made in Bay State applies here across the board and there's nothing to talk about. Isn't that sort of your position?
But if there was the issue to talk about that you're focusing on, Your Honor, that's not a point that the Attorney General made to the department in the course of the hearings. The department did.
Well, there weren't any. Which
well,
hearings?
no, there is a proceeding before the department that begins in December of 2005 and continues up until the department issues its decision in September of 2006. And there's various requests by the department for information and responses to that. That's where the Attorney General files his purported objection that based on the Fitchburg decision and the Coffey decision. But he never at any point says, well, look, what we need here is evidence of rate of return. And, you know, therefore there might have been, as he now suggests, a sort of sub-hearing of some type, adjudicatory or not, related to applying the cost of capital. But there was a hearing that was applying the Bay State case to Fitchburg.
I have one question. The policy here is intended to apply generally across the board, not company by company. And normally when you do that, I think the DPU does it by regulation. Is there a reason why the DPU did it by decision here rather than by regulation?
Well, I'm glad you raised that point because it seems to me rhetorically I ought to turn it around, not to you, but to the Attorney General and say, what if the Attorney General, what if the department had elected to use a rulemaking proceeding instead of this industry-wide adjudicatory proceeding?
I think then a lot of their arguments would go by the board then.
I think they would because...
So then my question is, why didn't you do it by regulation?
I can't answer why. I can only say that in this area that the department often acts by adjudication as opposed to by rulemaking, and the court has sustained that both for the department and others. I see that my time is up. Thank you very much.
Thank you, Mr. Berman. Good morning, Counsel. Is it Mr. Mueller or Mueller?
Mueller. May it please the Court,
Good morning.
Scott Mueller on behalf of Fitchburg Gas and Electric Light Company. I really think the issue here is coming down to whether or not the decision in the Bay State case was a policy change that the Department was allowed to then apply prospectively to other utilities without conducting a hearing under Section 94, or whether this was a general rate increase that triggered the hearing requirements under Section 94. And I do not believe that this was a general rate increase under Section 94 for several reasons. One, it was not a general rate increase because it only applied to a subset of the company's customers. In other words, the customers taking supply service.
But it does have an impact on other aspects of the rate, doesn't it?
It has an impact on those supply customers. It does not have, for transportation-only customers, it would not affect those customers.
But in terms of the company's rate of return, as a theoretical matter?
I think that, Your Honor, that is a factor. I think it's a de minimis factor. I think that is an issue that, just as the Attorney General suggested, that whether or not it should be at the Department's discretion to determine whether or not there should be a full-blown rate proceeding. I think it should be at the Department's discretion to determine whether or not this is such a significant formulaic change to the reconciling rate that it requires a hearing under Section 94.
Is there a case law that says that if it just has a de minimis impact on the overall tariff, that the Department does not have to hold a Section 94 hearing?
There is no case law. I think that's, as I said, a matter of the Department's discretion. And I would note that, the specific, I think it's important to focus on the specific change here. The only change, the formula change that we're talking about, is a single change to one definition in the company's CGA tariff, for example.
But isn't the question whether or not that single change will impact any of the other components of the tariff? And if it does impact those other components, then a Section 94 hearing is required.
I think that would be true if it was a general increase in rates, but I think that the Department has the discretion to determine, in applying Section 94, whether or not it is in fact a general increase in rates, and whether or not it is such a significant formulaic change that requires a hearing. And just to return to that definition, it's a change in the under the prior to Bay State, the Fitchburg tariff defined bad debt expense as the amount of bad debt determined in the company's last rate case in its test year, multiplied by an allocation factor which is established in each CGA proceeding. So that's a moving target. And that allocation factor reflects the ratio of supply bad debt expense to total bad debt expense. The only change, the change to the definition was to remove that reference to the test year bad debt expense and say that the company's bad debt expense is the uncollectible expense attributed to the company's gas cost, period. That's the entire formula change we're talking about here.
How can the public at large determine, or the Attorney General ever determine that the rate is a general increase, or at least the effect of the change will result in a general rate increase without a Section 94 hearing? I take it that the DPU has discretion to determine that it will not result in a general increase in rates. There is no Section 94 hearing. But don't you need the Section 94 hearing to determine whether or not there is a general increase in rates?
No, I think that should be at the Department's discretion, and certainly, as in this case, the Department did conduct some hearings where it thought that there was an issue of controversy, whether or not it should allow some retroactive recovery, and that's what, in this case, we had comments on.
That was the only part of this hearing that Mr. Bowman's talking about, was whether it should go back to cover all of 2005, correct?
That is correct.
So the issue about applying it prospectively was not what was the subject of that hearing.
That is correct.
Mr. Mueller, can I just ask you two questions? You've said several times that the impact was de minimis. How do we know that?
Well, you can certainly look at the change, and it's in the record, the change that the company was seeking. This isn't a case where bad debt recovery was moving from base rates to the CGA. This is a case where only an increment of that bad debt was moving because the department had essentially capped the bad debt recovery at the test year level. In the case of Fitchburg Gas and Electric, that increment for 2005, the first year this was applicable, was approximately $165,000. On the electric side, it was something under $300,000. That's compared to total revenues on the gas side of something in the range of 25 to 30 million, and on the electric side in the range of 60 to 70
Mr.
million.
Mueller, you would agree that the department never articulated what you've just said, that the reason we're not having a Section 94 hearing is that this is a de minimis rate increase, did it?
That's correct, Your Honor, because the department used a mechanism which it has used for many years, which was a stamp approval, in which it found that the company, in making its application, presented all of the rationale for approving the rate change, and the department merely stamped the company's request approved.
Let me understand let me see if I understood you right. In this case, bad debt, either on the electric side or the gas side, was not moved from the base rate to the CGAC or DF.
That's correct, Your Honor. The amount in controversy was merely not recovered by the company.
Okay, so nothing was moved to GCAC. The only thing you say is that the formula for the GCAC recovery of bad debt was changed.
I wouldn't call it a change in the formula. It was a change in a definition within the formula.
Lifting the cap.
Yes.
That's all that happened.
Correct.
But it would be the case if the company could not before recover what was capped, that increment. So that would be something that may have an effect on its overall rate of return, correct?
And again, Your Honor, I would take the position that that was a de minimis impact in the overall proceeding.
But in theory it could.
Yes, it could. I just want to raise one other point that hasn't been discussed today. The Attorney General has requested that the court reverse this case and require Fitchburg to refund the amounts collected. We believe that is inappropriate and inequitable because, as the court has noted, the company has since had new rates established for both its gas and electric divisions. That was based upon a finding that the company was under-earning, and I do not believe it would be equitable to now go back after the department has approved this charge and require a refund during a period in which the company was not earning its allowed return.
Thank you, Mr. Mueller.